I'm John Binns. I'm a financial crime lawyer with particular expertise in anti-money laundering or AML procedures. The issue with the Pandora Papers and indeed before that the Paradise Papers and the Panama Papers is divided, at least in the eyes of financial crime professionals, into two quite distinct things, but I think it's fair to say the public doesn't see it that way. The thing that links them is people or companies with plenty of money having to go through due diligence procedures with financial institutions and professionals that involve asking questions about their sources of wealth and verifying their identity and beneficial owners and that sort of thing. Traditionally, a lot of people who have a lot of wealth value their privacy, and it's hard to object to that on principle. Financial institutions and professionals legally need to ask these questions, and sometimes there's a bit of a tug between those two sets of interests where questions are asked and information is provided, and that's become a very well-established procedure. What the papers, I think, tend to show is that in some circumstances there will be things that the public are not happy with because they see the use of money or the handling of money as something that would be objectionable in some way or another. But this is where the distinction between the two issues comes up, because as far as I can see anyway, it's only a minority of cases that are revealed by these papers where actual criminal activity is involved, and that's what the financial professionals need to be looking at when they do their due diligence checks. There's a distinction famously between tax evasion and tax avoidance. Tax evasion is unlawful and tax avoidance isn't. The questions will also be aimed at looking at politically exposed persons and whether there's a suggestion of corruption or evidence of corruption or bribery as well. But what the financial institutions and the professionals are not doing is making moral judgments about people's money and rejecting people's business on that kind of basis. And so in the minds of financial crime specialists, that's a big distinction. I think the way these things are reported lumps those two sets of issues together, and the way perhaps it should be seen is that insofar as people have got a problem with things happening that are against the law, then obviously there should be more enforcement and people should be dealt with for breaking those laws. But insofar as people are doing things that are within the law and there are objections to that, then the answer must be to lobby for changes in the law. And it's an interesting distinction, one that maybe doesn't get picked up. I think it's fair to say, actually, as professionals in this area, we need to pay attention to the fact that there isn't always that distinction in the minds of people. And when people are dealing with money, it's also necessary to think about reputational risks, what happens if there's a leak, those sorts of things, because reputation matters as well, and businesses that are seen to act unethically can't always get away with it.